A single Supreme Court decision quietly reshapes how every gun law in the United States is evaluated, not by balancing public safety against individual rights, but by asking a far more rigid question rooted in history. In 2022, that's exactly what happened. In New York State Rifle and Pistol Association versus Bruen, the court didn't just strike down a licensing rule. It replaced decades of legal analysis with an entirely new constitutional test. And the ripple effects are still unfolding in courtrooms across the country. Here's the question I want you to think about as we begin. If modern gun laws must now be justified by practices from the 1700s or 1800s, what does that mean for today's society? Drop your thoughts in the comments. I'll be reading them. To understand why this ruling is so consequential, we need to step back and look at how the Second Amendment has been interpreted over time. The Second Amendment, ratified in 1791, states, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed." For much of American history, courts didn't treat this as an unlimited personal right. Instead, it was often viewed through the lens of militia service and collective security. That began to change in 2008 with District of Columbia versus Heller. In that case, the Supreme Court recognized, for the first time, that the Second Amendment protects an individual right to possess a firearm for self-defense, particularly within the home. 2 years later, in McDonald versus City of Chicago, the court held that this right applies to the states through the 14th Amendment. But even after those decisions, courts across the country used what's called a means-end scrutiny approach. In simple terms, judges would ask, does this gun law serve an important government interest, like public safety, and is it reasonably tailored to achieve that goal? This balancing test allowed many gun regulations to remain in place. Then came the Bruen decision, and everything shifted. The case itself centered on a New York law that required individuals to show proper cause to obtain a license to carry a concealed handgun in public. In practice, that meant applicants had to demonstrate a special need beyond general self-defense, something like a specific threat or occupation-related risk. The Supreme Court struck down that requirement. But the real impact wasn't just the outcome, it was the reasoning. The court rejected the traditional balancing test entirely. Instead, it introduced what's now known as the history and tradition standard. Under this approach, a gun regulation is constitutional only if it is consistent with the nation's historical tradition of firearm regulation, particularly around the time the Second Amendment was adopted. Let's pause and unpack that, because it's critical. Instead of asking whether a law makes sense today or whether it improves public safety, courts must now ask, is there a comparable historical precedent from the 18th or 19th century? If not, the law is likely unconstitutional. This is where things get complicated and controversial. Supporters of the ruling argue that it restores the original meaning of the Constitution. In their view, constitutional rights shouldn't expand or contract based on modern policy preferences. They believe the court is simply ensuring that the Second Amendment is treated like other fundamental rights, such as free speech or religious freedom, which are not typically subject to balancing tests. Critics, however, argue that this approach is too rigid. They point out that society has changed dramatically since the 1700s, both in terms of technology and public safety concerns. Firearms today are not the same as those that existed at the time of the founding. Applying historical analogies to modern regulations, they argue, can be difficult and sometimes impractical. And that tension is now playing out across the country. Since the Bruen decision, dozens of gun laws have been challenged in federal courts. Some have been struck down, others have been upheld. And in many cases, courts have reached conflicting conclusions, creating a patchwork of legal standards that may ultimately require further Supreme Court intervention. For example, laws regulating high-capacity magazines, restrictions on certain types of firearms, and limitations on where guns can be carried, like public transit or government buildings, are all being reevaluated under this new framework. Here's a practical example to make this clearer. Imagine a city passes a law banning firearms in crowded public spaces, like subways or large events. Under the old system, a court might say, this law promotes public safety and is reasonably tailored, so it's valid. But under Bruen, The question becomes, is there a historical tradition of banning firearms in similar public settings? If the answer isn't clear, the law could be struck down. That leads us to one of the biggest misconceptions about this ruling. Some people believe that Bruen makes all gun regulations unconstitutional. That's not accurate. The Supreme Court explicitly stated that certain long-standing restrictions remain valid, such as prohibitions on firearm possession by felons or laws banning guns in sensitive places like schools and courthouses. What Bruen does is change how those laws are evaluated, not automatically eliminate them. Another common myth is that the decision creates a free-for-all with no limits. In reality, courts are still upholding various regulations, especially when they can point to historical analogs. The challenge is determining what counts as a valid historical comparison, and that's where much of the current legal debate lies. At this point, you might be wondering how this affects everyday life. For most people, the immediate impact depends on where they live. Some states have responded by rewriting their gun laws to align with the new standard, often by removing discretionary elements and focusing on objective criteria. Others have expanded lists of sensitive places where firearms are restricted, leading to new legal challenges. If you're applying for a carry permit today, the process may look different than it did a few years ago. Requirements that once depended on subjective judgments, like demonstrating a special need, are increasingly being replaced with standardized criteria. But it's important to understand what the ruling does not do. It does not eliminate background checks. It does not invalidate all licensing systems. And it does not prevent states from regulating firearms entirely. It simply requires that those regulations be grounded in historical precedent. Now, here's where things become especially interesting from a legal perspective. The Bruen decision places a significant burden on courts and on lawyers. Judges are now expected to analyze historical records, statutes, and practices from centuries ago. That means diving into archives, examining early American laws, and determining whether they are sufficiently analogous to modern regulations. And that raises a deeper question. How do we interpret history? Historians often disagree on what certain laws meant or how widespread they were. Legal scholars debate whether a handful of historical examples is enough to establish a tradition, and courts must make these determinations in real cases with real consequences. In my analysis, this shift transforms the role of the judiciary. Instead of balancing competing interests, courts are now acting more like historical interpreters, trying to reconstruct the legal landscape of a very different era. That's not inherently good or bad, but it does introduce new challenges. Let's take a moment to address another misconception. Some assume that because the Second Amendment is being interpreted more strictly, other constitutional rights might follow the same path. While there are parallels, the Supreme Court has not applied this exact history and tradition test across all areas of constitutional law. Each right is interpreted within its own doctrinal framework. Still, Bruen signals a broader judicial philosophy, one that emphasizes original meaning and historical context. At this point, I'd like to hear from you again. Do you think relying on historical tradition is the right way to interpret modern constitutional rights? Or should courts have more flexibility to consider current realities? Share your perspective below. As we look ahead, one thing is clear. This area of law is far from settled. Several cases are already making their way through the federal courts, challenging everything from firearm bans to licensing requirements. Some of these cases may eventually reach the Supreme Court, giving it another opportunity to clarify or refine the Bruen framework. For ordinary Americans, the key takeaway is that gun laws are in a period of transition. What is legal today in one jurisdiction may be challenged tomorrow, and the outcomes of these cases could shape the legal landscape for years to come. Before we close, it's important to include a brief reminder. This discussion is for educational purposes only. Laws vary by jurisdiction, and if you have a specific legal question or concern, you should consult a qualified attorney who can provide advice tailored to your situation. So where does that leave us? First, the Supreme Court's decision fundamentally changed how gun laws are evaluated, replacing modern balancing tests with a historical analysis rooted in the nation's past. Second, This new standard is actively reshaping legal challenges across the country, leading to uncertainty and ongoing litigation. And third, the real-world impact depends on how courts continue to interpret and apply this framework in the years ahead. Understanding these developments matters because constitutional law isn't abstract. It directly affects everyday rights and responsibilities. Whether you own a firearm or not, these decisions influence public policy, legal standards, and the balance between individual rights and collective safety. We're witnessing a moment where legal interpretation is evolving in real time, and staying informed is one of the most powerful tools you have. If you found this breakdown helpful, consider sharing your thoughts, and if there's another case or legal topic you'd like explored in depth, let me know.